Hello everyone, today we are going to see about breach of contract. Breach of contract is a legal cause of action in which a binding agreement or bargain for exchange is not honored by one or more of the parties to the contract by non-performance. If the party does not fulfill his contractual promise or has given information to the other party that he will not perform his duty as mentioned in the contract, or if by his action and conduct he seems to be unable to perform the contract, he is said to be the breach of the contract. There are various types of breach of contract. The first one is anticipatory breach. The anticipatory breach is under the section 39. It occurs when the party declares its intention for not performing the contract before the performance is due. Thus, when a party refuses to perform a contract even before it is due for performance, it is called anticipatory breach. It may take place in two ways. The first one is expressly by words spoken or written. When a party to contract has refused to perform its promise. The second one is impliedly by the contact of one of the parties. When a party to a contract has disabled himself from performing his promise in its entirety. And the second breach is actual breach. Actual breach of contract may take place in any of the following in two ways. One, on due date of performance, that is, if any party to contract refuses or fails to perform as part of the contract at the time fixed for performance, that is called actual breach of contract. On due date of performance, for example, if X agreed to sell to Y 10 ton of wheat at 8,000 per ton to be delivered in two equal installments on so date, and X refused to deliver the goods on the particular date, it is an actual breach of contract on due date of performance. The next one is during the course of performance. If any party has performed a part of a contract and then refuses or fails to perform the remaining part of the contract, that is called actual breach of contract during the course of performance. For instance, X agreed to sell to Y 10 ton of wheat at 8,000 per ton to be delivered in two equal installments on 28th October and 21st October. On the particular date, X delivered 5 ton and refused to deliver remaining 5 ton. It is an actual breach of contract during the course of performance. There are some remedies for breach of contract. A remedy is the course of action available to the aggrieved party, that is, the party not at fault for the enforcement of a right under a contract. It has various remedies available to an aggrieved party as follows. Rescission of contract. When a breach of contract is committed by one party, the other party may sue to treat the contract as rescinded. In case the aggrieved party is freed from all its obligations under the contract. For example, A promises to B to supply 10 bags of rice on a certain date. B promises to pay the price on the receipt of the goods. A does not deliver the goods on the appointed day. B need to pay the price. The next one is shoot upon quantum merit. The term quantum merit indicates as much as earned or in proportion to the work done. A right to sue on a quantum merit arises where a contract partly performed by one party. In such cases, the plaintiff is entitled to the value of the services or the goods delivered till the moment of discharge, not on the basis of the original contract but on the basis of quasi-contract. The suit for specific performance means the actual carrying out of the contract by the parties thereto. Where a party fails to carry out the contract, the court may, at its discretion, direct the defendant to performance undertaking as per the terms of contract. Provisions regarding the granting of this relief are dealt with the specific Relief Act 1877. Suit for injunction is a mode of securing the specific performance of a negative term of the contract. Where a party in a contract is in the breach of negative term of a contract, that is, where he is doing something which is he promised not to do, the court may, in its discretion, issue an order to defendant restraining him from doing what he promised not to do. Such an order of the court is called an injunction. Suit for damages. The common law remedy for breach of contract is damages. Damages are monetary compensation adjusted to be paid to the injured party for the loss or injury suffered by him. The principle of awarding damages is to put the injured party in the same financial position as if the contract had been performed.